just first of all, your overall takeaway as to how the trial went.
The trial of Lori Vallow was clean, concise, and directly focused on Charles Vallow. The prosecutor on this case, Trina Kay, did a good job of trying a straightforward, uncomplicated, as much as you can uncomplicate this case. The issues are going to be very clear for the jury. It's really going to just come down to whether jurors can take circumstantial evidence and convict someone of conspiracy to commit murder. That's the Trina's challenge. That's going to be what she's going to have to connect those dots for in closing arguments. And this is a circumstantial evidence case. This is a complicated conspiracy that the prosecutors tried very cleanly. On the other hand, Lori Vallow has done an excellent job of being her own worst enemy. She has shown everyone she's smart, she's quick thinking, she's arrogant, and she's capable of pulling off a conspiracy. So her decision to represent herself candidly has become some of the best evidence the prosecutor could hope for.
Interesting. So you're saying that the jurors really saw who she is.
Yeah,
She's
yeah.
a good
It,
person.
yeah, absolutely. Because jurors go into a case, especially with mothers, wives.
You're
There
right.
is an implicit bias of people that's still out there on gender. It can be very difficult to convict women of certain type of crimes. Lori attempted to play the abused wife or the put upon wife, the targeted wife. She failed. I believe she's going to pay for that. And so in this situation, unlike in Idaho, you had a natural, would a mother really do that? Right? Would, as a mom, what mother could do that? And I remember thinking that at times myself, knowing the jury sitting there thinking, would a mother do that? Right? So here, this jury presumably does not know about the children, but they're going to think is a wife going to do that? Is really, why didn't she just divorce him? How do we know she really wanted him dead? Right? They're going to be thinking that. Had Lori not been her own lawyer, her lawyers would have gone after and probably would have gotten more of the evidence of the allegations of the steroid use, the allegations of his anger at her, his frustration at her. And so Lori just showed everybody what she's capable of and that she's not crazy, right? She may have bizarre beliefs, that is bizarre thought patterns. That's different than crazy,
Mm.
right? Evil sounds crazy to people who are normal and have a moral compass that points north. That sounds crazy. Sometimes it's just evil. And so her actions, her demeanor, her conversations have shown us who Lori really is.
Okay, so one of the main questions I've gotten all along is why can't the prosecutor tell the jury about Tylee and JJ and Tammy Daybell?
And in this situation, the murders of Tylee, Tammy, and JJ happened after the death of Charles. So when conduct happens after a particular crime, it can be very difficult to admit that information to show what somebody did before. It's the idea that the conspiracy to kill Charles would have occurred before Charles died. So, unless the court allows that sort of definition of conspiracy to be expanded to a greater overall conspiracy, then the court's not going to let it in.
Now, why would the judge say that if Lori, he told her at the beginning, if you decide to take the stand, he may need to tell the jurors about her convictions?
Under laws in most states, a person's felony convictions and or convictions related to dishonesty come in to impeach their credibility. That
Oh,
is longstanding principle of law. The court clearly was warning her that you're a convicted felon, you're a convicted murderer, and the jury may be entitled to hear that. He was probably going back and forth on the convictions happened after what happened to Charles, so maybe he should keep it out. But I think in the end, she would have been subject to cross about her previous convictions, and that would have opened the door to what happened to JJ and Tylee.
Are you surprised she didn't testify? Well, at least as of now, she hasn't testified. She could change her mind on Monday.
Lori could change her mind, but I am not surprised that Lori Vallow didn't testify. One, she was going to open the door, I think, to lots of things that has been successfully kept out or not even offered. And two, Lori likes to be in charge. Lori likes to be in control. Lori wants it to be the Lori show. Had she testified, she would have been subject to cross-examination by the prosecutor. And that prosecutor will be primed and ready and fingers crossed want it to happen. But in reality, Lori's not going to let anybody else be in charge. And on cross-examination, the person cross-examining is in charge. Lori's never going to let that happen.
I know so many of us wanted because she really hasn't answered questions to anyone.
Yeah.
If she were to take the stand and the prosecutor asks her these direct questions, what would happen if she said, I'm not going to answer that?
It would get used against her in closing argument. It would be very bad for her. Two, with a regular witness, the court can hold someone in contempt for not answering. What's he going to do? Jail Lori again?
Right.
So I think reality, Lori taking the fifth or saying I won't answer that after a period of time would only hurt her credibility in front of the jury. And if she's got to stand up there and do her closing argument, she doesn't want her credibility undermined. I think her closing argument is going to be Lori testifying. And I think we're going to hear Trina Kay do some objecting saying she's testifying.
How do you think the judges handled this? It's kind of a tricky situation with her. A lot of people have been like, he needs to quit giving her legal advice, but he's told her, I can't give you legal advice. And he's kind of remained out of the spotlight. Sometimes judges jump in and he's
Yeah.
kind of just, not in the background, but he's just letting things run.
The judges handled this with we call it pro se where I practice. Other places call it pro per, but
Right.
the pro se defendants are some of the hardest situations for a member of the bench and candidly for opposing counsel. You are very mindful that you have to follow all those rules. And so in this case, the court is paying attention. It's my understanding he's an experienced defense attorney prior to being a judge. He's a well-respected judge, talking to colleagues of mine from Maricopa County. He knows where those lines are. His experience as a former defense attorney, he knows where she is getting herself in trouble. And he's done some nudging there subtly to protect the record. The court has two responsibilities: to protect the party's rights and to protect the record so that a just outcome can be had and can be withstand scrutiny from higher courts. And so when the judge has jumped in, uh, he's done it subtly. He's done it by and large outside the presence of the jury. And he's done it in a way that makes it really clear that she wasn't railroaded. She was making an informed choice. And a person's right to counsel is your right to make informed choices. If you're your own lawyer, you don't get to complain that you had a bad lawyer as long as the system and the trial was fair. And that's what this judge has done.
Another huge question we've gotten, and I kind of addressed this last night with your help, but I want you to say it in your own words. The video of Charles going to the police for help, I believe it was January, February of 2019. We've seen it. Why didn't they show that?
And this is really hard for victims and victims' families. When a person has passed away, their statements are hearsay. There's probably no better defined situation than the statements of a victim that are recorded or written down by someone else than the statements of a victim that are put on recordings. And so Charles's statements to law enforcement are hearsay, classic definition of hearsay. There's a couple of exceptions, none of which were attempted in this case. So it is not admissible. I've had other cases where the victim's statements are not admissible unless I could find an exception to the hearsay rule. Doesn't, to my knowledge, I don't have evidence that the prosecutor tried. If she did, it would have been behind the scenes and with a hearing with the judge outside the public presence and outside the presence of the jury for many reasons. That's done to protect the right to fair trial of both parties. So Charles's statements to law enforcement are hearsay. The court has not found that there's an exception that lets them in. So, like in every other case, hearsay is not admissible.
Same with Tylee's police interview at the police station.
Say Tylee's statements to the police the day Charles were killed are hearsay.
Okay, let me go through some questions that our viewers sent in. I got a lot over the night. Someone mentioning the video, we talked about that. Um, what would happen if Lori Vallow wanted to call Chad Daybell as a witness?
Lori could one, she'd have to get him served and get a subpoena served on him to make him appear. His lawyers would quickly respond with a motion to quash and assert that he has a Fifth Amendment privilege. That would all occur outside the presence of a jury, and the judge would not allow it in. You cannot call someone for him to just take the stand and take the fifth. There's no way Chad Daybell is going to take this case or somehow implicate himself in Arizona. So he wouldn't have anything good to help her with, and his lawyers wouldn't let him, and the judge won't make him.
Here's my question for Rachel. This is from Tracy. To the jurors, it looks like Chandler didn't charge her for years, but there's a good reason for that we know that they don't. She was on the run and then either in a mental hospital or preparing for trial in Idaho. So it may look like they dragged their feet for years. Can they explain why they didn't charge her for so many years?
Well, they did charge her. So I forget what is the case number on this, Nate? Do you remember what?
I believe it's CR 21.
So the jurors will hear the case number, which will tell them when it was filed. So they know going into it that it was filed in 21. So the fact that things take a long time to go to trial, jurors just realize that. And Lori has not really driven that point home. So I don't think the jurors are going to worry about it. People know that the system takes a long time to go to trial. And the fact that they're there on a case number starting with 21, 2021, they're going to know that the charges have been around for a while.
Well, the other day, Lori mentioned about the grand jury, and the judge immediately told the jury to disregard it. Why?
The idea is, and the case law is like this across the country. The idea is if the jury hears that a grand jury has already voted to have charges proceed, that somehow it can lessen the burden on the state, that it can make the prosecutor's job easier because another jury's already found it. So the judges, I don't know of any place where the judge lets a lot of discussion about grand jury into the case without a really good reason. Because the idea is, hey, another jury's found her responsible or found enough evidence, so maybe we should too.
Dawn says, I like Trina Kay. Some of her questions seem very leading with her own witnesses. Do you think if Lori had more competent attorneys helping her, they would object? They would object to those questions.
Trina is leading. I've noticed that there is a lot of leading. However, it's kept the case moving. It's not inappropriate. It's very focused on what the obvious answer is going to come from the witness. So I don't think any of it is a problem on appeal. When you know the other side knows how to do it, you often let them go because it just slows it down. It makes it look like you're hiding things. So I think we would have seen some objections from a defense counsel, not a lot, because they know Trina knows how to ask the question correctly. Most of these witnesses have already testified, so they already know what they're going to say. Trina's just moving it along. I think we would have seen some, but nothing happening is something that's going to cause a problem on conviction. But I was a little jealous at her ability to lead some of that through the text, because text messages can get dull that's a hard testimony to make jury see as compelling. And I think Trina did a really nice job with that.
I remember in Idaho, you guys had the witnesses pretty much read every text, didn't you?
Hmm. Yeah, well, because we wanted them on the record, and the way the court wanted it done, it's a style choice. You're seeing different prosecutor style choices. I try really hard, especially with witnesses like Special Agent Doug Hart, now Chief Deputy Doug Hart. If I could have just stood up there and let Doug talk, I would have, because he's just such a great, compelling witness. He knew this case backwards and forwards. So I don't lead witnesses like Doug Hart. I want him to do the talking. But Trina was trying to move the case along. I suspect Nate Duncan was still not feeling great.
Yeah.
And when you have a witness who isn't feeling well, who isn't, maybe at the top of their game, I mean, his testimony was great, don't get me wrong, but your people, if they're not at their game or they're struggling, that's when you'll see a lawyer lead. They're trying to move it forward and trying to help their witness get through it.
Why do you think, I don't want to say they downplayed the sexy text messages, but they kind of did. I mean, they really minimized it versus in Idaho. Was that just, again, a choice of getting minimal, make it clear they were having the affair rather than sensationalize it, I guess you could say?
Well, yes, that was a trial strategy choice of the prosecution. You've got to remember her focus is about the death of Charles. Chad isn't charged. And they haven't alleged overtly that Chad was part of the conspiracy.
Mm-hmm.
So the more you put in there about Chad, his motive, his actions, the more you give somebody a chance to think, well, maybe Chad and Alex did this and Lori didn't, right? So you want to keep it super clean. You want to make sure that Lori the jury rightfully sees Lori's role in all this, which is a key leader, a key conspirator who candidly set her brother up with these beliefs that Charles had to die. The more you inject about Chad's motive as well, Chad's role as well, the more you muddy the waters on somebody who's not charged. Those sex things weren't just to sensationalize, it was to show the level of manipulation that Lori had over Chad.
Right.
So sex was a manipulation tool that Lori and Chad used on each other. It was mutual manipulation. And that sex was just one more tool in their arsenal.
Sensationalize was a poor word on
Yeah,
my.
yeah, no, I'm with you.
I meant maybe maybe we sensationalize it, but it did come out, and I know people. The lady next to me is like, "Get ready for the storm." Yesterday,
Yeah.
didn't even go there.
No,
Um,
because it wasn't about Lori leading Chad. This
right.
trial wasn't about Chad.
Right. Question for Rachel. This is from Carter. In many trials, I hear the judge instruct the jury that what the lawyers say is not testimony, and that only what the person on the witness stand says is. How does that work on a normal cross-examination or on such leading testimony that we have had on direct in this case? Does that instruction literally mean ignore the attorney's words? Or if they ask a question and someone answers yes, then you can take the words of the question to imply the meaning? I'm guessing it has to do with the latter, as otherwise 80% of the evidence in this case is yes or no. I can't wait to hear your answer.
You answered your own question. And so the answer to that is when a witness adopts part of what the lawyer says in a leading question, that becomes those witnesses' words. So if the witness says no, then the jury disregards the whole thing. If the witness says yes, then those words become the witness's words. It's about what the witness has to say. And so if the witness has adopted a leading question, those questions become the witnesses.
Can you ask Rachel some questions about the appeals process? Does the defense file the first appeal, or does the state automatically file as a quote audit of the trial?
Oh, that's a great question. No, the state does not file anything. The burden will be on Lori, and hopefully her standby counsel help her with this to file their notice of appeal. Almost every criminal defendant files an appeal. It doesn't matter whether they plead guilty or they're found guilty, they all appeal. The one exception will be is if Lori decides I'm done, I don't want to stay in Arizona, I want to get back to Idaho. So it may be that as soon as Brandon's case is done, Lori doesn't file appeals from Arizona and just gets herself back to Idaho. But technically, the burden's on the defense.
I know that Rachel doesn't know the answer to this, but I'm curious. Does she think that Lori fired the second shot into Charles's shoulder?
I don't know the answer to that, but I will tell you that would be inconsistent with the physical evidence. I know there's a degree to which people who feel so betrayed by Lori that they want to believe she pulled the trigger. Alex was the person who did her and Chad's dirty work by and large. I don't believe Lori pulled the trigger. She wanted to get out of there as quickly as possible, to get Tylee settled, to get their story straight, to make sure JJ was in a place where he wouldn't be questioned. So there was a reason Lori left. There was a reason Lori took JJ to school, got him his food so he didn't go to food school hungry. There's a reason she set that all up. And Lori didn't do her own dirty work. That was Alex's job. So my belief is that Alex did the shooting. They're too close in time together. Um, Charles was a strong big guy, and when you're shooting somebody to make sure you take them down, you don't pause to hand a gun to someone else.
Mm. Chelsea says, do you think they pre-planned everything the night before, like the visit to Walgreens and the visit to Burger King? Or do you think that it unfolded that morning, knowing Charles would be shot, and then they just went with what happened next?
I think it's the second piece that Lori and Alex planned for Charles to die. As we've seen in a couple other situations with them, they plan, but they aren't detailed people, right? They don't turn off their GPS. They leave their fingerprints on bags. They leave their DNA at scenes. So this was Charles needed to die that day before some sort of intervention. They needed to die before he could do more to reach out to Tammy. So he needed to die that day or close to that day, but they didn't go too far beyond that with details. I think they really they left the house without shoes on, or Tylee did. So they had to get Tylee shoes because it would look weird for Tylee to be walking around without shoes on. They needed shoes to get JJ in, and JJ couldn't go to school hungry. So I think she dealt with the cards she had and cleaned up the pieces she had. And they also needed time to kind of get their story straight.
Devin wants to know what you think the strongest piece of evidence is that the prosecution presented.
Oh, Lori's text. And multiple of those texts show Lori's intent, motive, and the conspiracy. This is technically what they call a circumstantial evidence case as to Lori, not as to Alex. So they needed Lori's words and participation and desire for Charles to die, and that's what they have.
Very good. Rachel, thank you so much. Is there anything
Sure.
you want to add?
No, I'll be very interested to see if Lori changes her mind and testifies, but I really don't think she will.
How long do you think the jury will be out with this?
You know what? And I couldn't see the jury, so I don't have an answer to that. If you have one or two who struggle, and this is going to be the prosecutor's challenge, a conspiracy case is hard because it's conviction for thoughts and words. And two, conspiracy case based on circumstantial evidence. You don't have go shoot Charles or shoot Charles this day. You don't have a direct admission. You don't have direct, she pulled the trigger evidence, we don't have video. So they're gonna have to be comfortable convicting of conspiracy and convicting based on connecting the dots and circumstantial evidence. So Trina's done an excellent job. The evidence is absolutely all in that they need, but it depends on if they have one or two jurors who struggle with those concepts. And unfortunately, not being able to see their faces, not being able to see how they're reacting to evidence, I don't know if you have what we call sleepers on that jury.
Yeah.
I don't think we do. I think it's clear as day. I think the state did absolutely everything they needed to do. The question will be whether there's one or two of them that just need time to be convinced.
Yeah. All right, Rachel, thank you.